Lady Antebellum, a country music trio of white people, has decided to get woke and show their racial sensitivity by removing Antebellum from their name and going by the name Lady A. What's the problem with this, you ask? Well, it's a person named Anita White who's been going by Lady A for the past 20 years. What's going on with this? Let's talk about it. Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, small law firm in central Minnesota. And today we're taking a little look at trademark law to discuss the ongoing dispute between Lady A and Lady A, or formerly the Lady Antebellum trio, who now wants to be known as Lady A, versus Anita White, a woman who's allegedly been known as Lady A and is a singer up in Seattle for the past 20 years. So let's take a look at the article in Billboard, and this will kind of walk us through what's going on, and then I'll add some flavor to that. So here you go. Right below me here, this is a picture of Anita White. You can see she is an African-American lady, and this is a picture of the white trio, who are definitely not African-American ladies, but are wanting to go by Lady A despite her claim to the name. Okay, so it says the band Lady A files lawsuit against singer Anita Lady A White. Exclusive. So the trio is asking a Nashville court to grant its right to the trademark Lady A. We're only going to go through the first section here, and then we'll talk about the issues going on. So attorneys for Lady A, formerly known as Lady Antebellum, have filed a suit against blues singer Anita White, who goes by the name Lady A. According to the suit filed Wednesday, July 8th in Nashville's U.S. District Court for the Middle District of Tennessee, the case arises from White's, quote, attempt to enforce purported trademark rights in a mark that plaintiffs have held for more than a decade. The suit also alleges that after conversations broke down between the band, whose members are Hillary Scott, Charles Kelly, and David Haywood, and the singer, Anita White, why don't they put her name in bold, and their respective attorneys, White's new counsel, quote, delivered a draft settlement agreement that included an exorbitant monetary demand. While the dollar figure is not mentioned in the suit, a statement concurrently issued by the band says the amount is $10 million. Quote, today we are sad to share that our sincere hope to join together with Anita White in unity and common purpose has ended, the group said in a statement. I'm going to hold off on the jokes. She and her team have demanded a $10 million payment. So reluctantly, we have come to the conclusion that we need to ask a court to affirm our right to continue to use the name Lady A trademark we have held for many years. And you can read the full statement below. But yes, it shouldn't be lost on anyone that the trio of white people tried to reach an amicable conclusion with the black lady, but when it didn't work out, they're now forced to sue the black lady to prove that the white people are right. This has nothing to do with the lawsuit and everything to do with how bad Lady Antebellum is looking and how contrary to their stated purpose this all is. But let's talk about what's actually been going on and what this statement means. It says they've owned Lady A for over a decade. And that is kind of interesting because as far as I know, they've gone by Lady Antebellum the entire time, and I've never seen the Lady A thing in use. Now, I'm not a fan. I'm familiar with the song Need You Now. It's a nice song, but I don't, other than that, I don't care particularly about Lady Antebellum as a band, so I don't know what use they've had of the mark Lady A. But let's kind of go through the history of what their trademark looks like, okay? And then I'll show you the document, the registration of the mark, so we can kind of look at dates, all right? Lady Antebellum filed for their trademark in 2010, saying that they've been using the mark for some time, and how trademark actually works. Or let's start real quick with what trademark is. Just a brief thing. Trademark is it's a recognition via a registration process through the United States Patent and Trademark Office. It's a recognition of your usage of a mark in trade or commerce, okay? And a mark is, it could be a lot of different things, but typically it's a name, a logo, something like that. It's a mark that identifies your commercial brand. If you think of Pepsi, not only the name Pepsi, but also the specific design of the Pepsi logo is a trademark. And so therefore, if someone else attempts to use that, Pepsi can say, no, 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 we own the right to this mark. We've been using it forever. We've registered it. And we don't want someone else thinking, or some customer thinking that they're buying our stuff if they're actually buying something else. That's the whole idea. The trademark office gives us some reliability as consumers that the thing we're buying is from the person we think made it, right? Is from the person who we think we're buying from. If I go buy Coca-Cola, I know it's not coming from Dave down the road because it's got the Coca-Cola mark. All right. So that's what a trademark is. Now, how you get it, you get a trademark actually by just using a trade name in commerce. If you're the first person to use a trade name in commerce, you get what's called a common law mark. And that means that you own the thing, you're doing the thing, but there's no official recognition from the Patent Trademark Office. Now, that recognition just kind of clears up some hurdles and steps and makes things clearer for everybody. That's the whole purpose of the registration system. But you don't have to go through it to actually own the rights to a trade name. It's really your first use in commerce, as long as there's not someone else using it in commerce first, that before you, that would come into conflict. So that's your common law mark. Now, Lady Antebellum has allegedly been using the mark Lady A in commerce since 2006. And I'll go ahead and pull up the document showing that. Here is the registration document from the Patent and Trademark Office. It was registered on July 26th of 2011. And you can see right down here, its first use is in 2006. They don't have the specific date, but they have the year 2006. And its use in commerce was April 14th, 2008. And it is for the mark Lady A. The mark consists of standard characters without claim to any particular font, style, size, or color. So this is just the mark Lady A. It's not like, art and bubble letters or something like that. It's just the mark, and the purposes are all there. You can see for entertainment services, live performances, concerts, all of that stuff, music videos, shows, all of that. That's just the actual category for the trademark, because sometimes you can have Dave's, I don't even know of an easy example, but you can have the same mark in completely different industries, and there's no thought that those two companies are the same, right? If one's making soda and the other is, I don't know, an industrial riveting company, they're not really you're not likely to think that the rivets being put into a steel building are made by Coca-Cola, is kind of the idea. And so there's no likelihood of customer confusion. So they do actually separate out categories, and you can own marks in different categories, or different people can own the same mark across different categories if there's no conflict. All right. So this is the certification. They applied for it in 2010. It was registered in 2011. And with that registration comes a public comment period where this goes, it gets published in one of the trademark registers, and then anyone can contest. They can contest the mark. They have a limited amount of time to contest the mark and say, no, this isn't correct. I actually own this, or someone else does. And if that doesn't happen and the mark is otherwise valid, the trademark office will recognize it. So it's very important to actually contest those marks if you own a company and don't have a registered trademark. It's important to look and make sure you actually don't need to be contesting it. But that's beside the point. Lady Antebellum did this. Anita White did not contest the mark during the public comment time, and so they were granted the registration. Now, further complicating this is the idea of what's called incontestability. That's when you own a registered mark for a certain amount of time. It's about 5 to 6 years. You can then file a Section 15 declaration, and that's Section 15 of the Lanham Act, which kind of sets all of this structure up. But you file a Section 15 declaration, and that can make your mark incontestable, which doesn't actually make it incontestable. That's kind of a misnomer, but it does make it much, much harder to contest. And it's a pretty powerful and effective weapon in heading off trademark challenges. But I say it's not incontestable because if a person can come out and prove that they were using the mark in commerce prior to you using the mark in commerce and prior to your registration of the mark, then you can actually overcome that incontestability. It's just difficult. And until you do overcome those hurdles, all of the presumptions go in favor of the mark holder in a court case. So, getting back to the subject at hand, Lady Antebellum is suing Anita White over the use of Lady A. But they're not asking to force Anita White to stop using Lady A or anything like that. They're just saying that there is an apparent conflict between the two over the rights to use Lady A. And they're framing it as a defensive move against Anita White, who could presumably sue them for trademark infringement. And that's based on the settlement offer and stuff like that. They're taking this defensive step proactively, saying that, well, we got a settlement offer. It was very hostile. We now think that she's going to sue us. So we want the court to recognize our registered mark and our valid ownership and usage of Lady A in trade. At this point, the judge may take that case on, but the judge may also say, I don't actually see a reasonable conflict here. I don't see a suit being filed, and I don't need to make this declaratory judgment. I won't exercise jurisdiction in this case. Not 100% sure. The judge can do either thing, and we'll have to just kind of wait and see what the ultimate outcome on that is. But right now, this lawsuit may end up getting dismissed before it even gets off the ground. Even if it doesn't get dismissed, the ultimate outcome would merely be a recognition of the valid use of Lady A. Now, if Anita White wants to countersue or open an entirely new suit for trademark infringement against Lady Antebellum, she could do that. And that's when things would get very, very interesting. And if she is able to effectively sue Lady Antebellum over years and years of trademark infringement, the damages could be they could be high. They're probably not going to be, because she would have to show how their use actually impacted her for the damage. And arguably, it really hasn't done so up until maybe now. But that would be her argument to make. Can't really judge the validity of it on a bare hypothetical. But Lady A has allegedly been using this mark for 20 years, which is longer than Lady Antebellum's use of it, which is a mere 14 years. If she can back that up, she will have a possibility of really making a lot of trouble for Lady Antebellum. But it can't be overstated how bad of a move this is for the White Antebellum trio to try and usurp the name of a black musician who's been using the name for longer in an attempt to show that they're not anti-black. It just doesn't play well. It's a terrible plan, and they should be laughed at for doing it. Filing suit was probably a mistake as well. And it'll be interesting to see how it goes. But I know there might be some confusion over what's going on, so I wanted to lay this video out and give you guys an idea of how all this came to be and what underlying facts there are with some documentation to kind of show it and what the arguments are right now. And the brief summary is that Lady Antebellum says that they've been using Lady A since 2006 and that they have a valid right to it. Anita White right now is alleging that she's been using it for even longer and that now she wants some compensation for them to use the mark. And how that ends up playing out will be for us to watch, I suppose. Hope you guys found this video informative and helpful and interesting. If you did, like it, share it, all of that good stuff, and watch again. Thanks a bunch. Have a good day. Peace. Peace.